You're charged with attempted to commit manufacturing or delivery of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. Here's the thing, you're on probation for burglary of habitation. It's involving the complainant, and there is a no contact order with the complainant. And then you have the case that you've just pled to. And the reason why the police were there is because there was an altercation and there was a female involved and there was a chunk of her hair missing. And you said it was a misunderstanding.
He walked into court with a deal for 5 years. He walked out with a sentence that was almost double. What happened in between is a masterclass in judicial power. This is Sergio Martinez. He's facing a serious drug charge, but his lawyer has a plan. By using a clever legal plea, they've struck a deal with the prosecutor for a short sentence. And it seems like a sure thing, but both of them have overlooked one tiny detail in the paperwork, a detail the judge is about to use to unravel their entire strategy and force Martinez to make a decision that will change the next 8 years of his life. As you watch this, ask yourself, is this a judge simply following the law, or is she teaching this defendant a lesson he'll never forget? Let me know what you decide.
Mr. Martinez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
Did you understand that your attorney has certain rights? He has the right to have 2 days pass once he's presented with the information and also 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? You're going to need to speak up. The court.
Yes, ma'am.
Court needs to hear. Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with attempted to commit manufacturing or delivery of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Are there any applications?
No, Your Honor.
Any objection to the court marking the box that says there are no applications?
No, Your Honor.
All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine, no applications. This will run concurrently with 2022 CR 7495. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest. It's a smart legal move. He isn't admitting guilt, but he's allowing the court to find him guilty anyway. It seems like a smooth path to his 5-year deal, but the prosecutor is about to say something that brings the entire proceeding to a screeching halt.
State any evidence.
Yes, Your Honor, State over State Exhibit 1 and all attachments, and then for the record, State wanted to make it clear that the labs have not been received yet in this case, but at the request of defense, we're proceeding with this case, despite that.
And that's why we're doing the attempted.
Then, all right, we can go off the record. So if y'all are going to do attempted and there are no labs, then there has to be a guilty plea, because otherwise, if the officers just did a presumptive test at a stop or something, that's not admissible into evidence.
He can change his plea, Your Honor, but you want to do that? Yeah, he'll change his plea.
All right, so how do you plead?
Guilty.
And there it is. He's trapped. The judge just explained that without lab evidence, a no contest plea is useless. His only path to the plea deal is to confess on the record. He says the word guilty, thinking he's just secured his 5-year sentence. He has no idea he just gave the judge all the power she needs to ignore that deal entirely.
All right. And then you're offering into evidence?
Yes, State Exhibit 1 and all attachments.
Any objections?
No, Your Honor.
All right. And Mr. Martinez,
Yes, ma'am.
do you understand you have a right to have the labs for this offense be given to your attorney so you can make an informed decision on whether or not this actually tested positive for methamphetamine or not?
Yes, ma'am.
And do you understand that any presumptive tests that were done by the officers in the field are not admissible?
Yes, ma'am.
Of course, if there are objections,
Yes, ma'am.
but it's not admissible into evidence. Do you understand that?
Yes, ma'am.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am. Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that he takes responsibility for what he's done and wants to go sit down for a little bit, come back to our community, and hopefully do a good job.
All right. Then the court will sentence you to 5 years in the prison. Court will give you credit for any time served. There's a $1,000 fine, time and money to run concurrent. This will run concurrent with 2022 CR 7495. There's to be no contact with Amanda DeLeon. There's to be no unsupervised contact with minors and no residing in household with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're proceeding in 2022 CR 7495. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Sergio Martinez Jr. who was placed on deferred adjudication in 2022 CR 7495 for the offense of burglary of a habitation on November 16, 2022 for a period of 8 years? Is that you?
Yes, ma'am.
State?
Violated condition number 4 in Bexar County, Texas, the defendant Sergio Martinez Jr. did then and there fail to report to the supervision officer as directed for the months of May, June, and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State will waive the rest.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison?
Yes, ma'am.
Hits just keep coming. Not only is he pleading guilty to a new felony, but he also violated his probation for a completely different crime. The judge is now looking at a much bigger picture of who this man is, and she doesn't like what she sees. But the real shock comes when she hears the details of his most recent arrest.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion, revoke community supervision, deferred adjudication, enter an adjudication of guilt, sentence to 5 years TDC, and run concurrent with 2025 CR 012772.
All right, has he done anything on probation? Have you done anything?
No.
All right. Then you have not done anything on probation. You're looking at 20 years. You're placed on probation for 8 years. So why should I give you 5 years?
I think I deserve another chance, ma'am.
No, I mean, here's the thing. You're on probation for burglary of habitation. It's involving the complainant, and there is a no contact order with the complainant. And then you have the case that you've just pled to. And the reason why the police were there is because there was an altercation and there was a female involved and there was a chunk of her hair missing. And you said it was a misunderstanding. So it appears that you have not learned anything. All right.
Thank you.
Thank you. So this is what the court is going to do. The court is finding violation of condition number 4 true. There's to be no contact with Teresa Sheets. This will run concurrent with 2025 CR 012772. Court will give you credit for any time served. There's to be no residing in any household with minors. There's to be no unsupervised contact with minors. And the court will sentence you to 8 years in the prison.
8 years, not 5. The defendant stands there stunned. By exposing the flaw in their plan, the judge cornered him into a guilty plea, giving her the authority to deliver a sentence she felt was just, completely overriding the deal his lawyer made. He thought he was playing the system, but in the end, the system played him.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement. I'm sorry, this is not a plea bargain agreement. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Great.
Any
Yes,
approach?
yes.
This is regarding the other pending case that the defendant had. Rick Pena for the record.
And the court is being tendered a dismissal in 2025 PF 37778.
Thank you, Your Honor.
So, in the end, what a turn of events. Sergio Martinez will spend the next 8 years in prison, 3 more than he and his lawyer ever expected. Did the judge overstep her bounds by cornering him into a guilty plea just so she could give him a harsher sentence? Or was this a brilliant move to assure real justice was served for a repeat offender? Drop your thoughts below.